Good morning. Happy Friday. Yes, I am recording this on Thursday night. We're dealing once again with Deboraugh, excuse me, and this petition for writ of habeas corpus that she has now filed, or someone has filed on her behalf. I'm not entirely sure. There are some problems with this, and in order to understand the problems with this, we need to take a slight trip down memory lane. Sure, memory lane. Once upon a time, Indian tribes were sovereign nations, completely sovereign nations. They ruled North America, the land that we now call the United States. And when the United States was formed and began taking territory to itself, it never fully integrated the peoples of those nations. And it has consistently, throughout the life of the United States, made treaties with them and otherwise dealt with them as sovereign nations. Now, they are limited now in their sovereignty because the federal government has power over them, but they are still, let's call them semi-sovereign nations with their own cultures and their own laws and their own backgrounds. And because they have their own semi-sovereign state, and because the United States Constitution does not address Indian tribes, it doesn't purport to be a contract between the states and the federal government and the Indian tribes. There was a problem in that Indians were not protected by the Constitution of the United States in tribal courts. So when they were dealing with tribal governments, if an Indian had an issue with their tribal government, or if they were in tribal courts, they were not protected by the United States Constitution. So Congress passed the Indian Civil Rights Act. And the Indian Civil Rights Act is codified somewhere around in here. And 25 U.S.C. 1302 gives Indians who are dealing with the Indian government or the Indian courts rights. It's fairly reminiscent of, but it's not the same as, the rights that are enumerated in the United States Constitution. And this only deals with Indian tribes and Indian courts. And the only remedy for violation of these constitutional rights that are given to Indians in Indian courts under 25 U.S.C. 1302 is 25 U.S.C. 1303. The privilege of the writ of habeas corpus shall be available to any person in a court of the United States to test the legality of his detention by order of an Indian tribe. So, the question that we have to ask ourselves is Deboraugh Rodgers in detention by order of an Indian tribe? Now, the 10th Circuit deals with the word detention differently than the 9th Circuit does. The 9th Circuit deals with detention the same way as it deals with the 10th Circuit deals with detention the same way it deals with the word custody in 28 U.S.C. 2254. Custody in this context, all the circuit courts agree that this custody just means that you're basically in the criminal process. You can be out on bond and still in custody, for this writ of habeas corpus. Now, the Ninth Circuit doesn't agree, and the Ninth Circuit interprets this as being actually in jail or in prison. So, if she gets out, her habeas, her petition for a writ of habeas is still going to be valid because she's still in the process. So she should not have used this particular form because this particular form is a 28 U.S.C. 2254, this one, which deals with states, people being held in state custody, state custody, state custody, state custody. And you can even see that it says for writ of habeas corpus by a person in state custody. Cherokee Nation is not a state. This does not apply. Now, that being said, how is the court going to look at this? They're going to say, well, Deboraugh Rodgers might not have used the right form, but did she allege things sufficient for us to grant her a writ of habeas corpus? Well, what was she convicted of? Contempt of court. That's interesting. So the only crime that she's alleging that she was convicted of is contempt of court. Now, has she exhausted her remedies? What they're asking about here is, did you exhaust your remedies? Now, you're going to say, John, exhaustion of remedies does not appear here. Well, that's why we have Valenzuela v. Silversmith. This is 10th Circuit, and 10th Circuit requires exhaustion of remedies. We conclude that the purposes underlying the tribal exhaustion rules support applying the rule to 1303 petitions. So you do have to exhaust your remedies. Now, there are exceptions to it. So what are the exceptions? The Supreme Court has explained that exhaustion of tribal remedies is not required, number one, where an assertion of tribal jurisdiction is motivated by a desire to harass or is conducted in bad faith. Now, I don't think the Cherokee Nation really gives any care as far as Deboraugh Rodgers. I don't think they're going out of their way to get her. I don't think that their assertion of jurisdiction is motivated by a desire to harass Deboraugh, or is conducted in bad faith. Number two, the action is patently violative of express jurisdictional prohibitions. Well, it's not patently violative, whatever, however you say that, of express jurisdictional prohibitions. She's contending that there is a jurisdictional issue there, but it's not patently, it's not obvious. It's not obviously violating express jurisdictional prohibitions. There is a plethora of case law in the 10th Circuit suggesting that the Cherokee Nation of Oklahoma has jurisdiction on the Indian reservation. The only question is that Deboraugh can raise is whether or not the UKB, the United Kituwa Band of Oklahoma, or something similar to that, whether or not they should have jurisdiction over her instead of the Cherokee Nation. And that is a question that, if it is resolved in her favor, is going to take some mighty fine legal jiggery-pokery to accomplish. It's going to take some mighty fine jiggery-pokery to accomplish. And the final thing is that exhaustion would be futile because lack of an adequate opportunity to challenge the court's jurisdiction. Well, she has an adequate opportunity to challenge the court's jurisdiction. It is still pending in the Supreme Court of the Cherokee Nation. Now, just because she's going to lose doesn't mean that she hasn't had she's not given an adequate opportunity to challenge it. I'm saying she's going to lose, but that doesn't mean that the Supreme Court of the Cherokee Nation says she's going to lose. And if you're going to suggest to me that courts will never say they don't have jurisdiction or will rarely say it, well, you don't know what you're talking about, because I would like to point out that Deboraugh Rodgers was initially slated to have this heard in a Oklahoma state court. And they said, wait a minute, we don't have jurisdiction, and they kicked it over to the Cherokee Nation. Excuse me, they dismissed it without prejudice, which allowed the Cherokee Nation to bring the charges. And you're going to say, well, why didn't the UKB bring the charges? Why didn't the Ketowa band bring the charges? Well, apparently they didn't care enough to. That's why. So she has to exhaust her remedies, and she didn't exhaust her remedies. So that's going to be a problem. Now, the court might overlook the fact that she's contending it's contempt when actually she's really contending that the underlying criminal charges that have not been adjudicated yet are the real reason. But who knows? We'll see how it goes. One other thing that I would like to point out is that she says that she was sentenced to 0 days, but she's still in custody. Let's see where it is. Let's see where it is. Here we go. Length of sentence, none. She was sentenced to none days. She's being held in jail right now because her bond was revoked. She's not being held in jail because of contempt of court. She's being held in jail pending arraignment. She's pending her bond being revoked. She hasn't even been... So, if you haven't been arraigned yet, if she's talking about her contempt, and she hasn't been arraigned yet on her contempt, that means she has not been convicted of it. Like, there's just so many things. This is why I try not to get into the sovereign citizen-y stuff, although I'm not sure if Deboraugh is a sovereign citizen or if she's just entitled. She feels entitled, and so she listens to people who tell her that they can get her what she wants. Anyway, I don't expect this is going to go very far once again, because she doesn't actually have an argument for it. She doesn't have a good legal argument, a good legal basis for it. And in the case of the habeas, she hasn't exhausted tribal remedies yet. And that's what I would bet, this isn't guaranteed, but I would bet the district court is going to kick it because of lack of exhaustion. Before they get to the merits, that's just going to be the easiest way to kick it out. You haven't exhausted your remedies yet. You state that you haven't. The result is pending. You state you haven't exhausted your remedies yet. So exhaust your remedies and then come back. Anyway, that's my analysis. Thank you for watching. Have a great day.